Welcome to Trust's Wills and Wealth podcast, protecting what you've built and planning for what matters.
Welcome back to Trust, Wills, and Wealth podcast, protecting what you've built and planning for what matters with Isaac Cohen, the podcast where we break down complex estate planning topics into clear, practical guidance for California families. Isaac is the founder of the Cohen firm, where he helps individuals protect their assets, their families, and their futures. I'm your host, Evan Mack, and today Isaac will discuss when and why you should update your estate plan after major life events. So let's dive right in. Isaac, welcome back, sir.
Thank you, Evan. Good to see you again. Thank you.
To see you too. Isaac, how often should Californians review their estate plan, even if nothing major has changed?
Yeah, I would say, look, even if somebody feels like their life is on, cruise control, everything's going well, I'd like to say every couple of years, pull out your documents. Look at your will, look at your trust, look at your power of attorney, look at your healthcare directive. Make sure that everything that you originally wanted, originally felt was the right decision for you still makes sense. If you don't do it every couple of years, don't let much more time go by. Some people will go 3-5 years without looking at those documents. Don't do that. Laws change. Your personal preferences will change. So you want to make sure that your estate plan always reflects your circumstances and how you want your estate to be administered.
So, Isaac, what happens if you get married or divorced but never update your estate plan?
Oh, wow. Great question. So marriages, divorces, those are some of the big events that will really necessitate for you to go pull out those documents and usually update them. You may need to revoke some of them. You may need to restate some of them. So a marriage is very important. So just because you get married, you have let's say a trust that was set up prior to being married, if you don't list your new spouse specifically in that document, it will be considered oftentimes in California that you intentionally omitted your spouse, and that spouse will not receive anything. So if it's your intention, if you don't want to have just separate property and leave everything to your kids, let's say from a previous marriage or to other family members, and you do want to provide for that spouse, you do need to update your trust, make sure that your new spouse is provided, or again, revoke the existing trust, create a community property trust here in California, a joint trust with the spouse that provides for both of you. On the flip side, what happens if you get divorced? Well, then the opposite problem can arise, where you have a spouse that's specifically listed in documents that you may not want. So in the trust, normally California will basically cancel any gifts to former spouses. The law normally will provide that in many circumstances, but it will not fix a power of attorney. It will not fix a healthcare directive, meaning that if you have your former spouse as your agent for healthcare and a healthcare directive, or if you have that person as your power of attorney, meaning that they can make decisions for you if you become incapacitated, if that's okay with you, fine. But if your ex-spouse is not who you want to make those decisions for you, then you do need to get those updated.
So how should an estate plan change after having those, there's children or even grandchildren?
Okay, well, we talked about, some traumatic, reasons. Well, marriage should never be traumatic, obviously.
It depends on who you talk to, Isaac.
But children, right. But let's say children, grandchildren, that's, the joyous occasions. So those also spark the reasons why you're going to want to update your documents. Children are born. First of all, you want to make sure that your estate plan provides for guardians. God forbid anything happens to the parents while the children are still minors. You want to make sure that you've provided guardians for their financial needs, for their personal needs. That's really important. Grandchildren is another reason. So grandchildren are born. You want to provide for them. Just because that there's new grandchildren in the family doesn't mean that they'll be provided for if you don't do it properly in your trust. And you want to have the proper provisions, the proper language there that will, let's say, limit a gift that you give to them for education, or if there's some possibly some spending habits for children or even grandchildren that are not the best, you may want to have provisions there that will protect them, and protect the assets, I should say, from those types of habits, things like that.
If you buy or sell a home in Cali, does your estate plan need to be updated?
Definitely. And that's one of the biggest mistakes that we see, where people will sell a home, they'll buy a new home, and they forget to update their estate plan, specifically their trust. And we touched about this on one of the other episodes, that when you buy real estate, new property in California, that property must be titled in the name of your trust, or you've just bought yourself a ticket to probate court. Again, probate court, you want to avoid it. It's public, it's expensive. It takes a year, 2 years, sometimes plus. So if you don't fund your trust properly, if your trust is not consistently properly funded, then you have assets that you believe are protected and they won't be. So if you buy a property, you amend your trust.
What estate planning updates should be made after a significant change in finances or maybe your assets?
Okay, so if you remember one of the prior episodes, we talked about the 3 Ds, of when you may want to update, or when you should update, I should say,
Yep.
your estate plan. There was death, there was divorce, and there was dollars. And what you're asking me about assets is dollars, meaning a big change in your financial profile. You bought a house, your finance went up. We talked about the house, but what happens if you have a business or start a business, and you have much more assets coming in? What if you inherit property, or are about to inherit property, whether it's real estate, whether it's cash? You need to update that trust to make sure provisions are in place to safeguard those additional assets.
We talked about it in probably a previous episode, somewhat, but how might a serious illness or diagnosis affect estate planning decisions for a person?
Yeah. So a diagnosis, an illness, that's the signal to go from a general estate plan to a very specific estate plan. So if you don't have a healthcare, an advanced healthcare directive in place, or if you have one, this is the time to pull it out, to review it, and make sure that the people, or the person or persons that you designated as your agent, your healthcare agent, is the right person, has the right wherewithal to represent you, to represent your interests during this prolonged period of illness, of incapacity. So if you don't have a healthcare directive in place, you need to set it up. If you do have one in place, again, this is the signal. This is the moment that you pull it out, review it. You have your brother, your sister placed as your healthcare agent. Can that person assist? Can that person rise up to the challenge that you may be having in the months ahead? If not, you need to adjust it.
Hmm. So, what problems do you commonly see when people forget to update that, the beneficiary designations?
Yeah, these are the silent killers.
Right.
People have set up a trust, set up their will, they have their power of attorney, they have their healthcare directive, and they put it in a drawer, they put it in the safe deposit box, and they don't look at it, they don't pull it out and review. So what do we want to look for? There's the forgotten generation. What does that mean? New kids have come into the picture. A couple has new children, grandchildren come into the picture. So with especially with children, just because you have child A and child B specifically named in your trust, if child C comes into the picture, that child likely will not take from the trust if that trust is not amended to specifically provide for that child. Same with grandchildren. If you want to make sure that grandchildren receive specifically, then that trust needs to be updated. Um, what about the aging of children? So let's say you set up your trust when your child was 5 years old. That was all well and good, but those provisions may no longer apply when that child is now 25. Um, if you had restrictions in place, if you had specific distribution schemes that you put for their protection, that may no longer be appropriate. They may be able to receive property directly, or they now may be the ones that should be the trustees of your trust, your healthcare agents, etc. So that's something that needs to be updated. Likewise, if you see that now that they're grown, they need extra protection, they're not able to handle money, handle property the way you'd like, then also that would be a signal for you to adjust the trust accordingly. Another one would be what we call the missing legacy. Let's say you have a couple or a single person that really feels strongly about leaving money to a charity, to a religious organization, and they always talk about it, but they never go and adjust their trust, change the terms to make sure that they receive that money, or they receive a gift. That organization, that institution will never receive the gift. So that's number one. Finally is retirement plans, 401ks, IRAs, and insurance policies, funds from insurance policies. Those normally do not go through a trust. So if you have a 401k, you have a retirement plan, you have life insurance policy, you want to make sure that the beneficiaries that you designate in those retirement plans, in those policies, line up with who you have as beneficiaries in your trust. Because if you want to make sure that those people in your trust are the only ones that are receiving your property, but 10, 20 years ago you set up your retirement account through your employer, and you named cousin Sally as the beneficiary because there really wasn't anyone else in your life at the time, you want to make sure that gets changed. So that would be the final one. Make sure everything works together seamlessly. We talk about a cohesive strategy, that your plan isn't just, oh, I've got one thing saying this and one thing saying that, but exactly, this is how I want my property to go. This is how I want my wishes to be expressed, and that everything, including things outside the trust, align with your estate documents.
So what kind of outdated estate plans cause unintended consequences for families that you've seen?
So we call these the zombie plans, where somebody sets up a trust, again, 10 years ago, 20 years ago, when the laws were different. So you have, we see lots of times people will come in and say, look, I need to update my trust. And we look at the trust and we basically say, it's not that you need to update it. We need to what's called restate it. We need to start from scratch. We keep the shell, but we're going to redo all of the language, because before you had A/B trusts, you had sub-trusts, you had complex distribution schemes because the tax laws were not very advantageous, and you really had to get creative. Now in 2026, we have federal tax exemptions for estates, 15 million per if you're an individual, 30 million if you're a married couple. So we don't need all these fancy, and fancy is a nice way of saying overly complex types of trusts that really will cause more paperwork. Many times will end up causing people now to pay more taxes than they would have if they just had a very simple, to the point trust that's crafted for current laws and the current circumstances.
And finally, before we go, Isaac, what are some other major life events that would bring, about the need to meet with you, if someone thinks their estate plan might be out of date?
Okay, so there's a few, basic ones. Number one, people that have trusts in place, that have estate plans in place, that set them up in a state other than California, that moved to California. You want to make sure that somebody reviews that trust, make sure that it complies with California-specific rules and statutes and regulations, and that it just gets tweaked or gets a fine-tuning to be so that it'll work properly under California. Children, we talked about children. Obviously, if there's new children that you want to provide for, that if you have children or a child that turns 18. So again, my example, you set up a trust that was great when your child was 5. Now the child is 18 or 20 or 25, but he's already of majority age. You want to update that trust to make sure that the child is properly provided for in that trust in a way that makes sense with the current circumstances. Again, if that child is now responsible to the point that you feel he or she should be the trustee of the trust or the executor of the will or be one of your agents, either for healthcare or for finances, this is the time to do it. What about changing what we call the functionaries? So the trustee of the trust, the executor of the will, your power of attorney, your healthcare directive, somebody that you may thought was the right person and who you felt comfortable being in that position 5 years ago, 10 years ago, 20 years ago. Is that person still here? Number two, is that person still someone that you feel comfortable being in that position? If not, it's time to make usually a very simple amendment to your documents to change that person or to add somebody in a backup position, whatever is necessary, to remedy that situation. And then finally, if you've opened up a new business, started a new business, have a large inheritance coming, it might be time, very often it is, to have that trust reviewed, have that trust amended if necessary to have the proper provisions so that these new assets, that your business is properly looked after. Should anything happen to you, whether, meaning after you pass or that you're still living but are no longer able, in the case of the business, to operate that business while you're living, or in the case of inheriting, additional wealth, additional property, not able to distribute that, or make sure that things are in place to care for those assets.
Awesome stuff, Mr. Cohen. Appreciate the time, sir.
Thank you, Evan. Thank you very much. Until the next time.
Till the next time. And thank you all for listening to Trust, Wills, and Wealth podcast, protecting what you've built and planning for what matters. If your life has changed and your estate plan hasn't, visit thecohenfirm.com to learn more. Be sure to like, subscribe, and share this episode. And thanks again for tuning in. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.